Welcome and thank you for tuning in to your estate planning workshop hosted by myself and my team of paralegals, Andrea and Tiffany, that help me with everything I do around here. A little bit more about me. My name is Troy Moore. I'm a licensed Texas attorney since November of 2001, and I have been a solo practitioner since July of 2008. Please check out my online reputation, which precedes me. I'm up to 82 Google reviews now, all for 5 stars. And please feel free to read the reviews because most of them actually deal with estate planning and probate type matters from people's estates. So let's get right into it. What you'll learn today is how to name guardians for your minor children, how to avoid probate court, your estate planning options, the difference between a will and a trust, and how to protect your children's inheritance. So the big question, do you currently have an estate plan? You may think you do, you may think you don't. You might not think you have an estate plan, but you do. It's just the state of Texas has written it for you. Estate planning is opting out of Texas's default estate plan for your family and your assets and where the deed to your house goes. So if you don't do a will, you end up in the land of Texas descent and distribution, which is just the name for the legal effect of not having a will in Texas. And what happens is your property gets run through this complex collection of pie charts, depending on who you were married to, how many children you had, and so on and so forth, which ultimately determines who gets what from your estate, all of which may go to sometimes people that you do not want. So here's what you probably think happens. So husband gets married to wife, they buy a house together, and then husband passes away. And you might think that it's automatic that the house passes to the wife upon the husband's death. But in Texas, it is not. There is no right of survivorship for a spouse in the homestead residence, even in the absence of a will. This is a shock to most people. And what happens in real life all too often that I see in my office is something like this. Husband gets married to a wife. Husband has kids from a prior marriage, marries wife, they have one child together. Husband, like we do, passes away first. And what happens next in the absence of a will might surprise you, because the surviving spouse gets 0 from the husband regarding the home. 100% of the husband's ownership in the home then passes to all of his children equally. And this is in the instance of when there is no will. This results in a very shocking situation for a lot of people in blended families, and there is an easy way around it. So the solution is husband has kids from a prior marriage, gets married to wife, they have their child together, husband and wife perform some estate planning, then husband passes away again, and the end result is happy wife, happy life. With proper estate planning, the beneficiary can sell the house because it is not a probate asset, can refinance the mortgage, can take out a home equity line of credit, and call the mortgage bank and get answers, all of which may not be possible without proper estate planning. So what is an estate? Well, it's your bank accounts, your checking accounts, your savings accounts, your cars, boats, motorcycles, brokerage accounts, any stocks and bonds that you own, the proceeds from your life insurance, your house, and any other real estate that you have, retirement accounts, IRA accounts, any jewelry, artwork, intellectual property such as trademarks or patents, and any business interest that you may own, like an LLC or a small corporation. So the goals of your estate planning is to give what you have to who you want, when you want, the way you want, all the while avoiding probate court and to maximizing the assets that end up distributed to your loved ones. Also, estate planning helps to care for your own self during your lifetime and any incapacity that happens, while allowing you to fulfill your charitable intentions after you're gone and minimizing taxes due at your death. And also, estate planning allows you to care for and protect others after you're gone, such as your surviving spouse and children, so you can pass on your values and ideals to them and protect those assets from creditors, divorce, and bankruptcy. So the downsides to dying intestate, and intestate is just the legal word for dying without a will. If you die without a will, your assets will get distributed according to state law, which could go to people you don't want. Kids will get the inheritance at 18 and outright, which means that it could be lost in a divorce or just spent unwisely. Your surviving spouse can remarry after your death, leaving the money to a new spouse and other kids. If there's a dispute over anything, a judge is going to decide who raises your minor children, as well as a judge will decide who's in control of your children's money. And all of this is in probate court, which is guaranteed. So what is probate court? Well, probate court is where the court appoints an executor over your estate that can take charge of your property. At probate court, we publish a notice to creditors that goes in a legal newspaper, and also notices to beneficiaries, and we provide the court with an inventory of what was in the estate with an appraisal of the assets. This allows the executor to then distribute the assets. All of this is reported to the judge. We need court permission sometimes to do some things, and you pretty much always have to hire a lawyer. 3 downsides to probate is it's expensive, time-consuming, and public. Probate costs $5,000 per person, even with a will, and when you're married, you have to do probate for each of you after you pass away. So, and when you have a probate case that exists downtown, it's an open lawsuit. Anybody that wants to interfere with your estate can go down there and read all of the filings. They can send a letter to a judge, which can bring to a halt anything you're trying to get done in probate. So in order to figure out what goes to probate court, we have to look at this asset characterization chart, which is a good reference point for what goes to probate and what doesn't. So the probate assets on the left bucket, that is what goes through probate court. The non-probate assets on the right, all of things with beneficiary designations or like trust assets, joint bank accounts, those things are non-probate assets and do not go through probate court. So in order to determine your costs of death, you want to think about what is in store. If you pass away without a will for a married couple, the minimum cost of probate is going to be $15,000. Who's going to be in control of your estate? Well, it's out of your control at that point, and it's going to be up to the agreement of other people on who is in control. The time frame for how long it will take will be indefinite, because if there's a dispute over things, then it could take forever. Now, if you have a will and there's a married couple, your probate cost is going to be about $9,000 in today's numbers. The benefit is for control, you get to decide who's in control now. The time frame for it is also sped up with a will as far as how long things takes, and it takes about 30 to 90 days. So the other package that I offer that avoids the whole probate process is Probate Avoidance Package. The cost at that point for probate is $0. Your control is totally in your possession, and you decide to control now. The time frame is immediate, because once you pass away, everything immediately transfers to the beneficiaries under that package. And sometimes the probate avoidance package isn't the best for your situation. People will have children that are younger, and there's going to be somebody that needs to manage their money, or you might have rental property or business interests that somebody's going to have to manage things after you're gone. If there's future control that's required, we need to go with a revocable trust package. And again, the future cost of probate for a married couple is $0. You decide now who is in control of your estate, because it's all transferred to the trust, and the time frame for how long it takes when it's transferred to a trust it depends, because you sometimes want a trust to last for years so it can manage the money for children or rental property or whatever the situation is. So next, the 3 options that you have generally in Texas. The first option is doing a last will and testament as your primary method of estate planning. You know you're going to probate court in this situation, and we still do powers of attorney. But option 2, we have a probate avoidance package, which we still prepare a basic will, but this uses a combination of other things to avoid probate court. Or option 3, which also avoids probate, is the revocable living trust package. All of these involve doing powers of attorney for you for all of those decisions while you're alive. Now, let's look into each one of those. If you do a will package, this is better than nothing, as you can see from the cost of death. A will does designate guardians for your minor children. It designates beneficiaries for assets owned by you individually, and it designates an executor to wrap up your affairs and speeds up the length of probate. So when is a will-based plan appropriate for you? Well, if you just want to name guardians for your minors and you don't care about probate costs, such as if you're leaving your estate to a charity, in that case, probate avoidance is not your goal, so a will-based plan is sufficient. But if you don't want a will-based plan and you want to avoid probate court, then what's the answer? Well, at this point, you have two different options. And so the first option is a better option, the probate avoidance package. So most everything you own right now is probably a probate asset. What we do with the probate avoidance package is we position your assets, both your real property and your personal property, to pass directly to your children while you still maintain control over all of your assets. We do this with a combination of transfer on death deeds, powers of attorney, and beneficiary designations that activate upon your death, ultimately resulting in the benefit of everything that you own bypasses probate when you pass away. So here's an example where the probate avoidance package works well for our fictional client, Anakin. Anakin has a $500,000 house and he wants to leave it to his son, Luke, when he dies. Well, this works for Anakin because in this instance, Luke is already grown and he wants it to be simple for Luke to take over the house. So in this instance, Anakin needs a probate avoidance package because it is the easy button for his situation. Now, this is brand new information for a lot of people, and that you can avoid probate court this way. So if you need more control over the assets after you're gone, an even better option is doing a revocable living trust. So everything you own now is outside of a trust unless you have one. What we do with a revocable trust is it moves your assets into your trust by retitling them into your trust. You still maintain control over all the assets in your trust, and we do this by a deed of your house into the trust, along with powers of attorney and a specialized deed as well. The benefit results in everything in your trust bypasses probate when you pass away. So there are three roles in every trust. There's the grantor or the settlor. This is the person who actually creates the trust and contributes the property to the trust. And then there's the trustee. That's the person who manages the trust assets and who has the checkbook, if you will. And then there's the beneficiary of the trust, and that's who's entitled to receive distributions from the trust. In the beginning, you normally occupy all three positions. You're the settlor, you're also the trustee and the beneficiary. All of these roles change over time after you pass away and different things happen in the future. So the revocable trust package is more like a kid's backpack is a very good metaphor to explain it. So you want to have things in the backpack for it to work because the trust only works for items that it owns. So an empty backpack, things that are not in the trust, is bad. You want to have your house in the trust. We retitle the car and set up bank accounts to where they transfer to the trust. Items that are in the backpack is good. So an example of where a revocable trust package works for our fictional client, Leah. Leah has a $500,000 homestead and she wants to leave it to her son, Ben, after she's gone. But in this example, Ben is not 25 years of age and he has not graduated college. Leah wants Ben to have had those two things happen before he receives his money at that point. Leah needs a revocable living trust package so that a future trustee can take control of the money until Ben turns 25, until Ben graduates college, and then at that point, turn the money over to Ben to spend at his discretion. So the trust package solves all the problems that come with a will because you won't lose a good chunk of your estate in probate court. The assets go to your family in weeks and not years, and it's totally private during life and at death. With transfer of property through a trust, There is no occurrences in probate court. Nobody can look up your trust like they can with corporations or LLCs. The only way people find out about trusts is if they have business with them. So it's a lot more difficult to interfere with a trust or any type of property exchange that it is doing. Everything really just happens behind the scenes. So included in the revocable trust is a children's trust that manages their money until they get older. The children's trust holds the children's inheritance, and the kids can still squeeze out money from the tube of toothpaste, if you will, when they need it. But what remains in the tube is protected from lawsuits, bankruptcy, and divorce. The best part is you get to pick the trustee, which can also be your adult child. And this protects your children's inheritance while still giving them access to it. So you just want to squeeze out a little bit from the trust at a time, because what does come out from the trust is subject to collection and division by courts. So you might be wondering, if I do a trust, what about guardians? Well, in the instance where we do a trust package, you still get a pour-over will with your revocable living trust. And this is where we nominate the guardians for your minor children. So I would caution you to beware of DIY or do-it-yourself documents, because why most estate plans fail is because of DIY documents or just poorly drafted documents that do not avoid probate, or that have not been timely updated to reflect the true wishes of the person who passed away currently. Or most estate plans will fail if the children get the inheritance at 18, which is highly unadvisable, and it is not protected from divorce, bankruptcy, or lawsuits. So when you work with an attorney like myself, you are paying for the guidance and counseling about how the documents should be drafted, not the documents themselves. So the traditional experience people have with estate planning firms is hourly billing, it's reactive and transaction-based. And here at my office, we do things mostly on a flat fee. We have a relationship-based future with you, and we're more proactive because we don't just want to do your documents one time and then never see you again. You want to update these documents every 3 to 5 years. We want to have a relationship with you so that when the time comes, your documents work for you the best way possible. So our estate planning process is a 4-step process. You're doing the first one right now, attending the workshop, and then the second is doing the design meeting, where we'll meet together at my office. Then we go away and draft your documents, and then you come back and we have a signing meeting where we go over everything in detail, and then you sign your documents and leave with the original. Now, at the design meeting, if you're married, I need both spouses to attend. You'll fill out an online questionnaire before you come in. I will go over all of your questions and discuss your goals with you personally, and we will design your estate plan at that meeting. You might be wondering, well, why should I do this now? Well, do your future self a favor, because probate is expensive, public, and time-consuming. This will give you peace of mind that your future wishes are going to be fulfilled, and you should not wait for significant medical events to occur, because they happen unexpectedly, and you might not be able to get these documents done after one of those occur. Doing your estate planning will protect your children's money and their future care, so that's important to most people. And you really want to keep in mind that in Texas, your spouses do not automatically inherit your homestead residence, and doing this estate planning can save you yourself a lot of money, not just your children. So how much does everything cost? Well, the will package is the silver package. That is $2,000. The probate avoidance package is $3,000. And the revocable living trust package is $3,500. If you're single, take $500 off of all of those prices, and that will be your price for each package. The most popular packages are the gold and platinum packages, since they obviously avoid probate. So as a special offer, and a thank you for educating yourself and watching this video, just reference this $250 offer, and we will give you a credit towards any estate plan that you pick with our office for making it this far in the video. And if you're ready to move forward, Here's the QR code that you can scan on your left. It will take you to my electronic business card on your right, and then you can tap on your phone or on the computer, book your estate planning appointment, and it will take you to another screen where you can pick a design package where you can select an appointment time to get on my calendar. That pretty much wraps up everything I had to deliver to you. This information is really informative. Be sure to tell your friends and tell your family. Don't wait until it's too late to think about your estate planning. And I look forward to seeing you soon planning your estate. Thanks.